Welcome back to the second of our online lectures for week 2. This is the part 2 of our discussion of consideration. And you recall that we divided the discussion of consideration into 5 parts. In the first class, we looked at the elements of consideration, the benefit detriment requirement and the bargain requirement. Now in this class, we're going to pick up with the final 4 topics, beginning with how much is enough, then the rule with respect to past consideration and the existing legal duty rule, and finally and briefly, a discussion of the functions of consideration. So jumping into the first one for today, which is how much is enough. And here the book describes how courts and writers draw a distinction between adequate consideration and sufficient consideration. And the general rule is that consideration, it must be sufficient, but does not need to be adequate. Now, the book also acknowledges, and I think this is right, that the terms are not always used with perfect consistency. It's not surprising because adequate and sufficient, these terms are, in general use, they're often used as synonyms. So it's not on the face of it clear what the difference is, which is indicated by the words themselves. But of course, that's fine. It's the concepts rather than the words that we're interested in. It's the concept behind that, and the concept itself is clear, which is the principle that consideration must be of some value, but it does not have to be of equal value or commensurate value or similar value to that which it is exchanged for. So it must be capable of being regarded as having some value. It must have a value greater than 0, if you like, but it's not required to be of a similar or equal value to that for which it's exchanged. For various reasons, the common law just does not inquire into adequacy. Or to put it another way, the court doesn't generally inquire into the fairness of bargains. All that is required under this rule is that there be something given in exchange for the promise of the other. And the reasons for this are discussed by President Kirby in the extract that you have in the materials from the case of Woolworths and Kelly. It's not necessary for me to repeat here what his honour says in that case. It's put clearly there. But I just want to be very clear about this because it may be counterintuitive to you, but it is the case that even a small amount of consideration is sufficient to make a binding promise. Now, you'll come across in this context references to the term peppercorn consideration, or perhaps to leases charging a peppercorn rent. And that's obviously based on the idea that even a peppercorn can be enough a consideration for something value. Well, and here's a quote from a kind of famous quote on this topic. A contracting party can stipulate for whatever consideration it chooses. A peppercorn is enough, and it doesn't cease to be good consideration even if it's proven that the promisee doesn't like pepper and will throw away the corn. It kind of also makes a point. It's about the value of it, not what subjectively you think of it. But it is possible where the parties, knowing that they need some consideration to make an agreement enforceable, include a small amount of consideration just to ensure that this clause is complied with. If you Google or search, you'll be able to find references to, peppercorn consideration clauses that are designed to fulfill this purpose. Now, so the fact that there is a great disparity between the value of the promise and the value of the consideration given for it, the fact that that a bargain is uneven, it might be relevant to other questions. It might be relevant to whether there was unconscionability, which is an equitable doctrine, an equitable cause of action. It might be relevant to whether there was fraud. There are particular situations also where the courts are authorised to inquire into the fairness of agreements, but that's because particular laws enable that. And an important example is consumer law. Under Australian consumer law, Parliament has empowered courts in this narrow situation, in this particular class of contracts, to inquire into the fairness of certain contracts, of consumer contracts or certain consumer contracts. And one of the factors in determining whether a term is unfair is whether there is an unbalance in the rights and obligations of the parties. But that's a narrow exception to the general rule. And the general rule is that common law rule, which is that the courts don't inquire into the fairness of bargains or into the adequacy of consideration. Now, this is a good point to mention deeds. You may or may not have come across deeds previously. These can be thought of as agreements with a higher level of formality. So a deed you can think of it as being a bit above just a normal agreement, certainly in terms of the formality required. Traditionally, they were written on a certain type of material and they had to be signed, sealed and delivered. Again, that's you may have heard, signed, sealed and delivered. So that's why when sometimes you will refer to, you'll see them referred to as agreements under seal. So in the case of Foulkes and Beer in the readings, there was a reference to agreements under seal. That's a reference to a deed. And why this matters, why it really matters, is the key point is, and this is practically very important, is that promises made in a deed do not require consideration to be enforceable. So they fulfill the purpose of ensuring that certain promises can be enforceable even in the absence of consideration. The parties can reduce them to this document. If it is executed as a deed, then it can be legally enforceable. So it means that when lawyers are worried that in an agreement that consideration may be an issue, a common response is to put it in the agreement in a deed. So for example, there's multiple parties and it's that each party is giving each other party consideration. It may be reduced to a deed. Another is gifts. You'll see sometimes references to a deed of gift. And of course, the nature of the gift is it's a promise given for no consideration. And so that can be made enforceable by putting it into a deed. So deeds perform that very important practical function where there are concerns about consideration. All right, so moving on to the next topic, which is past consideration, where the general rule is that past consideration is not considered valuable, or to put it in another way, it's not considered sufficient, using that language from earlier. And of course, we see this rule considered in Roskala and Thomas. So here, Roskala bought a horse from Thomas. And after the sale was complete, Thomas, the vendor of the horse, he made certain representations to Roskala about the horse's temperament and nature, to the effect that it was a good horse, that it was free from vice, which was not the case. That wasn't true at all. Roskala subsequently found out that the horse was, quote unquote, very vicious, restive, ungovernable, and ferocious. And so he sought damages for breach of warranty. Now, the key point to understand in this case is that the promise as to the horse's temperament was made after the sale was complete. So if you like, as Roskala was leaving with the horse, he'd bought it and he's on the way out. And Thomas says to him, oh yeah, by the way, it's a great horse, free from vice, etc., etc. So consequently, the court said that promise was not enforceable under contract law because there was no consideration given for that promise. In the words of Lord Denham, in the present case, the only promise that was coexistent with the consideration, that is, the only promise in the initial bargain, the payment of the money in return for, was to deliver the horse. There was no promise about the condition or the nature of the horse in the original bargain. So the warranty came later. So I've put in here a kind of timeline to illustrate the point. So the bargain was here, the offer and acceptance occurred here, and at that point there was no promise as to the nature of the horse. Promise was made later. So you can see from this, there's in terms of identifying when there's offer and acceptance, and how I've spoke last week about how that's important for clarifying when the bargain was formed, which is, as you can see from this example, then important to ascertaining the terms of the bargain. So if a promise is made after the bargain is complete, it can't be linked back to it because that's the consideration given under that earlier agreement is in the past. So perhaps I'll just give another example to illustrate. Say if yesterday you and I met for coffee, and at that coffee I gave you my bike. I just gave it to you, and you took it home and you're riding it, and you're so pleased with it that you text me and you say, oh, Leon, this bike is awesome. I have to give you money for it. I seriously must. I sincerely promise that next week when I see you, I'm going to give you $200 for the bike. Now, again, that promise would not be legally enforceable. Even though you're promising $200 for the bike has already been to you. It's attached to past consideration, so it wouldn't be enforceable. There is an exception to the rule, which is described in the short extract that's on Moodle from the case of Pao Ong. And in that case, Lord Scarman described the exception in the following terms. He said, an act done before the giving of a promise to make a payment or confer some benefit. So act done before the promise can sometimes be consideration where these three requirements are met. So first, the act must have been done at the request of the promisor. Secondly, the parties must have understood that the act was to be remunerated, either by a payment or the conferment of some other benefit. And thirdly, the payment or the promised benefit under the subsequent promise, that must be legally enforceable, had it been promised in advance. But that's not particularly tricky. Wouldn't be confused about that. I mean, that just means that it must be a benefit of a type that's enforceable. To give a very obvious example, a promise to be someone's friend forever is not a legally enforceable a promise, whereas a promise to make a payment to someone, for example, quite clearly is, or a promise to transfer goods to someone quite clearly is. So perhaps I'll give an example. Say A owns a shop and he engages his artist friend B to paint a sign on the front window of the shop. And so they understand that B is going to be paid for her work, but they don't discuss the exact fee. When B's finished and A sees the sign that B's painted, he's so pleased with it that he says, he offers to pay her $600. He says, right, I'm going to pay you $600. It's fantastic. I'm so pleased with it. I'll pay you $600. And that might be $300 more or double the market rate, which, in the absence of an express clause, that market rate might be how you would have calculated what she was entitled to, what B was entitled to. So he's promised to pay $600, but the only consideration for that promise is in the past. It's the painting of the window, which she's already done. But according to this exception, it can be linked back to the terms of the original contract. It's either regarded as an admission which provides evidence of the bargain, or it kind of positively fixes the amount in the bargain. But it's always in circumstances where the parties have understood that there was going to be remuneration, but they haven't fully articulated, they haven't crystallized what that amount was. And if there's a subsequent promise, that can be, if you like, the crystallization of that amount. That's the nature of the exception. Terrific. Now we turn to the existing legal duty rule. And we spend a bit of time on this because we look at, firstly, the general rule, and then the particular situation of part payment of a debt, where we look at the case of Foulkes and Bien. And then we look at three exceptions to the rule. The practical benefit exception, on which there are two cases, Williams and Roffey Brothers and Musumeci. Promises to third parties, you don't have a case on that, but I'll cover off on that quickly. And then the third exception we look at is the one described in Wigan and Edwards, which is that of genuine compromise. So we'll start with the general rule, and I'll come back to just reminding you where all of the topics that we're covering. But the general rule is that the law does not regard either the performance of or a promise to perform an existing legal duty as legally valuable consideration for a new promise. So it's not seen as being sufficient, where all you're doing is performing an existing duty or promising to perform an existing duty. That's not seen as being sufficient consideration, simply because it's seen as nothing new. And this normally arises, as the facts illustrate, in the context of a variation, as the cases illustrate, sorry, in the context of a variation to the terms of an existing agreement, where that variation is for the benefit of one party only. So in the context, so you've made a contract, and during the course of the execution of the contract, there's a variation, and the variation's for the benefit of one party only. So I want to be clear about this. Where the parties have made a contract, maybe to build a house or whatever. And in the middle of performing a contract, the parties agree to vary it in a way that benefits both parties. That's fine. There's no issue. That variation is enforceable. So to give the building example, you agree to vary it by adding a further window for which you're going to pay more money. That's fine. Each party's given consideration. That variation is enforceable. Or to give another example, say you and I have a contract under which I've promised to pay you a certain amount of money in return for you promising to provide 600 printed t-shirts by the end of September. Now, say you run into trouble and you realize you're not going to be able to meet that September deadline. And so you ask for a variation to the agreement. If we vary it in a way that benefits us both, then we each provide fresh consideration and the variation is enforceable. So say I extend the deadline to the end of October, that benefits you, in return for you including 5 extra shirts. It doesn't have to be significant consideration, it just needs to be new consideration. Then there's consideration, there's consideration each way for the variation, and the variation is enforceable, it's binding upon us. But if we agree to vary the existing agreement in a way that benefits one party only, it's different. So say in that situation, you've contracted to provide the shirts by the end of September. Say if I agree to extend the deadline until the end of October, so that's a variation, but you give nothing in return, except for the fact that you promise to continue to print the shirts, which is of course what you're already contractually required to do. So here, there's no consideration for my promise to accept the new deadline because you're bringing nothing new. What you're doing is what you're already required to do, what you're already under an existing legal duty to do. So that's the nature of the general rule. In that example I gave, there may in fact be an estoppel. We'll come back to estoppel later on, but in contract law, the starting point is that there's no consideration for my promise to extend the deadline. So it's not binding on me. It's not binding on me, that promise, under contract law. Of course, unless there's an exception. All right, so that's the general rule. We go on to consider the specific situation of a part payment of a debt. It's a very particular case. And here we look at the case of folks in beer about this. So this came about because in some years earlier, in 1875, beer had obtained a judgment against folks for the sum of £2,090, including costs. So that meant that obviously folks was now under a legal duty to pay that amount to beer. Right. But in terms of how he would do so, there was still the question of how the debt was going to be enforced. And to that end, the parties entered into, if you like, a payment plan. And that was contained in a written agreement. And the agreement was as follows, that return for folks paying beer, so this amount paying it, but initially paying, so here it was by paying £500, upfront upon signing, then £150 every 6 months until the full amount was paid. So this was kind of like this installment plan to be paid over, actually, if you work it out over the course of 5 years, bit by bit, until the full £2,090 was made. So that's what folk promised to do. And in return, beer promised not to take proceedings on the judgment. So not to take enforcement proceedings on that amount. So there was a finalized agreement in those terms. It was, there was promises made each way. It was in writing, etc., etc. Now the issue was that it took several years, 5 years, for their debt to be paid. But due to an oversight, the agreement didn't make any reference to interest. So there was no provision for the payment of interest that would have accrued on the debt during that period. And so beer commenced proceedings to recover an amount for interest. So if folks did make the payments, paid the full £2,090 over the course of those years per the repayment plan, but hadn't paid interest, so beer commenced court action to recover an amount for interest, and folks pointed to the agreement. and said that in the agreement she'd made a promise not to take court action. He said he'd upheld his side of the bargain. He'd paid the £500 up front, and he'd paid £150 each 6 months until the full amount was paid. So now Beer was required to comply with her side of the bargain by not taking court proceedings, that she was bound by the promise. But the House of Lords disagreed. And why? Because they said that folks had not provided any consideration for Beer's promise not to commence proceedings. So in that agreement that folks tried to rely on, all that he was required to do, all that he'd promised to do, was what he was already obliged to do. He promised to pay that £2,090 by instalments. So it was like structuring his existing obligation, but there was nothing new that he brought to it. All that he was promising to do was his existing legal duty. All he was promising to do was to pay the debt that he already owed. And consequently, there was nothing he'd actually brought to the agreement. And it was not enforceable against Beer, and she was free to take proceedings against him. Now, the outcome would have been different if under that agreement, folks had provided something that could be regarded as fresh or novel consideration, something fresh or something new. So, for example, if he also gave security for the debt, that might not be a term that means a lot to you for the moment, but it is something you'll become more familiar with. So, an example is a mortgage. If you give security for a debt, it means that you're attaching property to its payment in a way which means if it's not paid, the other person's got the right to seek to be able to sell the property for its payment. And that means that if, for example, you go bankrupt, you get lifted above the other creditors. So in a commercial sense, it's a very valuable thing. It's why banks always require that you have a mortgage when they lend you money to buy a house. So if it included security, then it would have been enforceable because that's new. But it didn't, not in this instance. And it would have also been enforceable if, for example, do you remember that, recall that the first payment was a £500 and then followed by 150 every 6 months. Say instead of that, if folks had given a horse that was worth £500 and then thereafter paid the £150. So if instead of £500 itself, he gave a horse to the value of £500, that too would have been enforceable because that's a change to the existing arrangements. That would have been considered fresh consideration. It's a bit like courts. Even though it's of the same value, courts, as we know, don't inquire into the adequacy of consideration. So it would have enforced it as a new bargain. But that wasn't the case here. And so the agreement wasn't enforceable. Now, there's no doubt as to the legal correctness of this decision, but there has been some debate about whether it is a good rule. Shortly, we're going to look at the practical benefit exception to the existing legal duty rule, Roffey Brothers, etc. But it currently appears that this exception does not extend to part payment of a debt. And to be clear, there often is a practical benefit in having part of your debt paid immediately or soon, rather than waiting for it to be paid in installments or having to pursue court action to get it, recovered through whatever mechanism. For example, there's always, for starters, the ever-present risk of bankruptcy. So it's often the case, there's the saying, a bird in hand is worth two in the bush, and that kind of applies here. It's often the case in business that people will accept immediate part payment of a debt rather than leave unpaid the full debt, for whatever discount that might include. And as was said in Folks in Beer by Lord Blackburn, men of business do every day recognise and act on the ground that prompt payment of part of their demand may be more beneficial to them than it would be to insist on their rights to try and enforce the whole payment. So in a commercial real world sense, there is a practical benefit sometimes. There is thought to be a commercial benefit to part payment of a debt. But despite this, in the case of Re Selectmove, there's the 1991 English Court of Appeal case. It's extracted very briefly at paragraph 4.135 of the readings. In that, the court said that the practical benefit exception does not extend to part payment of a debt. And that appears also, that was an English case, but it does appear also to be the position in Australia. I mean, it's yet to be definitively settled here, but that does appear that it's likely to be the position here as well. Okay, terrific. So we've looked at the general rule and we've looked at that particular situation of part payment of a debt. And, you know, so the rule with part payment of a debt is that, you know, you owe me $100, you pay 90 to me now. I say, great, I'll take that as being everything. That promise is not binding on me. I can still pursue you for the extra $10. So part payment of a debt is captured by the general rule. I should sort of clarify then. So if you are going to, in practice, then when lawyers are dealing with a situation of like part payment, you can of course use a deed to make such a promise enforceable. Now we're going to the exceptions to the rule, and we're going to look at the three: the practical benefit exception, promises made to third parties, and genuine compromises. Starting with the practical benefit exception, which was first identified in 1991 in the English case of Williams and Roffey Brothers. So here, Roffey Brothers and Nichols Contractors was the full name of the company, and they were contractors, they were builders, and they were contracted to refurbish a block of 27 flats. And they engaged subcontractors to carry out much of the work, and that included the appellant Williams, who was a carpenter, and they subcontracted him to carry out the carpentry. And the subcontract with Williams provided that he would get $20,000 for all of the carpentry work on all of the 27 flats. And it became clear that this was too little. It was something that both parties recognised when Williams got into financial difficulties. And so following a discussion, they formed an oral agreement that Williams would get an additional £10,300 at the rate of $575 per completed flat. So that's actually was a 50% increase in his fee that they negotiated. So the initial agreement was that he would, for £20,000, do the carpentry on all of the flats in the block. It became clear that it was too little that he charged. He was in financial trouble, and so they made a subsequent agreement, an oral agreement, under which Roffey Brothers agreed to pay him an extra $10,000 and an extra 50%, an extra £10,300, and so, and in return for it, we'll come back to that. But Williams then substantially completed a further 8 flats. But then the relationship between the parties really fell apart. There was serious conflict, and he downed tools. He walked away. At that point, Roffey Brothers had only paid him a further £1,500, and so he stopped work altogether. Which meant, of course, that Roffey Brothers, they suffered delays. They had to find a replacement carpenter to finish off the work in the flats, and so the matter went to court. Now, each party sued. Williams sued Roffey Brothers for the payments that he said he was owed, and Roffey Brothers counterclaimed against Williams, saying that he had breached the contract by stopping work. Now, so part of the case turned on the question of whether Williams was justified in stopping work. He said he was because they hadn't been making the payments, but you don't need to turn yourself with that side of the case that Williams did succeed on. That we're interested today in the question of the legal status of this second agreement, this oral agreement that was made after it became clear that Williams was in financial trouble. So it's a good starting point when you're faced with these sort of situations, always just to clarify what it is that's alleged to be the bargain. So what it is, it's said that each party bought, what each party's consideration is said to be. So again, our focus, we're concerned about the enforceability of this second agreement. And it's clear that what Roffey Brothers had promised, they'd promised to pay that additional amount of money. But in return, what Williams had promised was to continue to do the carpentry work on each of the flats. There was nothing further than that. There was nothing in addition to that. So in the words of Glidewell, what Williams was promising to do was no more than what's already bound to do by the original subcontract. That is, to continue with the carpentry work and to complete it on time. And again, that's what he was already obliged to do under the original contract. And so what he was promising to do under that second contract was no more than he'd already promised to do under the first contract. So that is, he was under an existing legal duty, and so it was said there was no consideration for the variation. Now, the counter argument made here was that, yes, although the Roffey brothers didn't gain any new legal rights under that variation, the second agreement, they did gain a practical benefit. And that's what we're talking about here. They gained a practical benefit from his promise to complete the contract. Those benefits, it was said, were, or perhaps would have been if the relationship hadn't substantially deteriorated, but at the time of making the subsequent agreement, those agreements were going to be ensuring that Williams didn't stop work in breach of the contract. So avoiding the trouble and expense of engaging another carpenter, and also avoiding the risk of a penalty for late completion under the head contract. So sure, I mean, if Williams did stop work, they could have sued him for breach of contract, but there's still the very significant cost and imposition of finding a replacement, dealing with the risks of fines under the head contract, all that stuff. It is recognised that sure, you've got a legal right to sue someone, but it's far better for them to have done to have done what they were required to do under the agreement in a practical sense. And the court accepted this. They agreed. They did say that Roffey brothers gained a practical benefit, but they accepted also that it wasn't a legal benefit. In a real-world commercial setting, they did say that the significance of a practical benefit should not be understated, though. As the facts demonstrate, a practical benefit is something that business people actually place significant monetary value on. And the courts were sort of persuaded to some extent that they should be giving weight to that. That was a compelling argument for giving effect to the variation or to the agreement for a bonus, if you like. And so Lord Glidewell said in the extracted judgment that you have, he effectively said, well, there are compelling arguments for giving effect to the variation because it did give this practical benefit. But before we allow that, we need to consider the logic, the rationale for the rule, the original rule, for the rule that a promise to perform an existing legal duty is not good consideration. So what is the rationale for that rule in the first place? So he discussed some of the cases in the commentary. He went back as far as the decision of Stilken Mirrick, that 1809 case about the ship where the two sailors deserted in the Baltic, and the remaining crew were promised their share of the wages if they stayed on board. And he tried to unpick the rationale for the rule. And so why have this rule? And he concluded that one of the main reasons was concerns about to prevent economic duress. So it's clearly not in the public interest to allow subcontractors, for example, to threaten to put a head contractor in breach of the head contract so as to extract a higher fee. The risk with variations and with making them enforceable in the absence of fresh consideration is that of economic duress. So in this situation, say if Williams had turned around and said to Roffey brothers, yeah, well, you're going to suffer these significant penalties if you don't finish the flats on time, so I want some more money. I'm going to down my tools until that. So, and I need a variation for you to increase my fee. That sort of, the risk of duress is something Glidewell said was very much motivating this rule. He thought that this is concern, he thought that this is what motivated the court in Stilken Mirrick. He pointed to developments in the law of duress in the period since then, which he thought, meant that it could be considered fresh. That the economic duress, it's not a very well developed area of law in contract. It's still quite limited, but he did say, it was evolving, and so he then went on to say, well, I think, there is a case for exception. And then look, I mean, it has to be said, given that this was a case establishing an exception that didn't exist previously, it could be argued that the case could have been, they could have been a bit more thorough in their arguments in terms of, why they developed the exception. But But nevertheless, the full court, or the Lords, Glidewell, Russell, Purchase, they all decided that there was a practical benefit here in Williams promising to continue to provide the carpentry service, and that this practical benefit could, in the circumstances, be regarded as valid consideration for the promise to pay an additional £10,300. And so the practical benefit exception was created. Now, it's important to note that the court also did try to put boundaries around this exception. They didn't. It wasn't just. It is not simply the case you can say our practical benefit therefore exception applies. In fact, they came up with a 5-part test, which was designed to meet some of the concerns about having such an exception. That was the logic. They said, we think it's useful. We think it reflects commercial reality to have such an exception, but we also recognise there are concerns about it, including the one about duress, and so we're going to put some rules about when it applies. And those are the 5. That's the 5-part test described in this slide. So B must have engaged A to perform work or supply goods, and during the performance, B must have reason to doubt whether A will or will be able to complete that work. And so B promises an additional payment to A if A completes on time, and as a result of that, B obtains a practical benefit. And it must be the case that that additional promise, the promise of an additional payment, was not given as a result of duress or fraud. And where all 5 criteria are met, then the practical benefit can be regarded as good consideration, such that the promise of the additional payment is binding on him or her. So the key point here is that it's not enough when you come across in this in practice to say, practical benefit, therefore exception applies. You do need to check whether the elements of the 5-part test are all satisfied. You know, it may not necessarily be the case that you've got to discuss them all in detail, but you do need to consider in any given scenario whether each of the criteria of those 5-part test have been satisfied. Applying it here, Roffey Brothers had engaged Williams to perform work. And during the performance, Roffey Brothers did have reason to doubt whether Williams was going to be able to complete. So Roffey Brothers promised to pay an additional amount if Williams completed on time. And as a result, they concluded Roffey Brothers did obtain a practical benefit. And there was nothing here to suggest that there had been duress. There was nothing here to suggest that Williams was trying to pressure them. There was nothing to suggest that the promise was given as a result of duress or fraud. And so the exception applied here. Okay, terrific. So that of course meant that the variation was enforceable. This was an English Court of Appeal case, and it established in England that precedent for the practical benefit exception. But that's not, as you know, automatically binding on Australian courts. It then fell to be determined whether or not courts in country would follow the English lead. In some cases, you will be aware that the law in the two countries diverges. So the opportunity to consider this rule in the Australian and specifically the New South Wales context arose just 3 years later in this 1994 case of Musumeci and Winnedell. And I want to be clear about the significance of this case. This was a decision of Superior Court. It's a Supreme Court New South Wales decision, but it's also the decision of a single judge, Justice Santo. So for practices in New South Wales, it is authoritative, but it's not as authoritative as a decision of the Court of Appeal or as a decision of the High Court, in which we don't have yet on this topic. So it's got weight, but only weight to that extent. And the facts in Musumeci were as follows. Winnedell was the owner of a shopping centre in which Musumeci was the tenant of a fruit shop, as per the picture here, a fruit and vegetable shop. And it came to, so there was a shopping centre where Musumeci had a fruit and vegetable shop. And it came to pass that the landlord allowed another fruit and vegetable shop to move into the shopping centre. And of course, this was going to impact on the business and the viability of Musumeci's fruit and veggie shop, because there was going to be competition in that same shopping centre. So after discussion, the landlords at Wynedel, they agreed to reduce the rent by about a third. And so for a period of time, they collected only the reduced rent. But sometime later, they sought to resolve from that promise or revoke that promise and to revert to the full amount of the rent that, as it was set out in the lease. So they promised to accept a reduced rent, but then they later sought to resolve from that promise. Now, again, this was a situation of a variation to an existing agreement. So, the amount, the existing lease, this was a variation, and it's a variation that benefits one party only. So if it had been a variation that benefited both parties, there's fresh consideration, that's all clear. But it was only Musumeci who benefited here, who benefited in the form of a reduced rent. There was nothing new or additional in the sense that was brought for the benefit of Wynedel, for the landlord. And so the question before the court was, well, was this variation, was this promise to accept reduced rent, was this binding on the landlord? And so, of course, this was the first case in New South Wales to consider the question of whether the practical benefit should be applied here. And it should be noted, it raised the question of whether the exception should be extended slightly. The situation is different here. This was a promise to reduce a burden rather than a promise to grant a benefit. So in Roffey Brothers, the promise was to pay the subcontractor more, to pay an additional £10,300. Here, the promise was to charge the tenant less. So it's just slightly a different scenario. And in the event, Justice Santos said that difference doesn't matter, but that was part of what the court had to consider. Right, so and you'll see that in his judgment, Justice Santos, he went through a process of considering the reasons why contracts to perform an existing obligation were generally not enforceable. And he kind of focused on three reasons. He said, well, one was to protect against extortion. This was also obviously discussed in Roffey Brothers as well. The risk of allowing parties to vary agreements and make those agreements enforceable is that one party might pressure the other to do so, by threatening to pull out if they don't, in circumstances where that's going to cause the other party to suffer. So we might say, we agree that you pay me $500 to fix your internet, but I realize that if I don't fix it for you, then you can't run your business. It's going to take you days to find someone else. So I say, right, I'm not going to do it unless you pay me $1,000. So that's the extortion concern. And it's been argued that, the requirement for consideration is designed to help prevent such extortion, because the variation for the benefit of one party only is non-enforceable. But Justice Santos, he wasn't he wasn't particularly persuaded by that. He said that, the requirement for consideration, it provides only limited protection against extortion. In fact, he said that even the presence of consideration doesn't preclude there having been economic duress inducing a contract. And in fact, consideration expressed in formalistic terms, so peppercorn consideration of $1, can indeed actually cloak duress. So consideration doesn't always do a good job of preventing duress or preventing an unfair variation or an unfair bargain in general terms. So he wasn't persuaded that the requirement for fresh consideration actually performed this role in all circumstances well. And he certainly also thought that if we are going to have an exception for a practical benefit, that can be taken into account. The second reason that promises to perform an existing obligation were generally not enforceable was because in legal terms there was nothing new on offer. And we've seen this, the legal obligations on the other party remain exactly the same. So the obligation, going back to Williams, the obligation was to perform the carpentry work on all of the units. There was nothing new. The obligations on him were exactly the same, and the legal rights of the other party were exactly the same. So in legal terms, there's just no change. It's just there's existing legal duty. And again, Justice Santos said, well, he recognised that, but he also said it was not insurmountable. He pointed to the fact that the law is increasingly tending away from the artificial or the conceptual and towards the substantive. And such a practical notion of consideration of practical benefit reflects that trend. So he's saying that, courts shouldn't get caught up in legal formalism, where in the real world, commercially minded parties in their transactions are actually seeing it as being valuable to bind parties by virtue of there being a practical benefit, then the court should be cognizant of that. Is another way of paraphrasing what he was concluding here. So that while there may be no change to the legal rights and obligations, courts they can and should take account of the real world practical benefit that the parties themselves have recognised. And it was a bit less clear exactly about what he was getting at, but the concern appears to be that if there is a practical benefit exception, it would be so broad as to effectively do away with the existing legal duty rule. That is, the exception would be as big as the rule. And it would be to completely undermine the rule. And he basically disagreed with that proposition. He said it would still be the case, there would still be room for the original rule to apply. There won't always be a practical benefit exception. Subsequent cases have been at pains to treat the case as good law, but it must be in the case of a wholly gratuitous promise. So on that basis, after that discussion, he decided, well, I think that the rule should apply in New South Wales, and he applied it. It's important to note that he also did then modify that 5-part test from Williams and Roffey Brothers. And he said, he looked at it and he said, look, it needs a little bit more work. And so he took the words of Lord Glidewell and he changed them a little. He created he added more words to the point where there's too much to fit on a slide. He created a new and slightly more elaborate test. It's still a 5-part test, but it's different in 3 ways. He expanded the scope of the rule to include variations that reduce an existing obligation, not just promises to provide a new benefit. So to cover, promise to accept reduced rent, not just a promise to pay more money. That's not a massive change. He broadened the categories of coercive activity that would disqualify the use of the rule. So beyond just economic duress, he talked about unconscionability or undue influence. And he tightened the rule by effectively saying that the purported practical benefit actually be capable of being seen as a benefit. Giving the court more scope to say, all right, in fact, was there really a benefit here for the test to apply? So it's too long for me to put it up here or to repeat the full test here. It's easy for you to find it in the materials, but again, the important thing is, well, 2 things really. One, you're required to ensure that all 5 elements apply. It's not enough to just say, there's a practical benefit, therefore an exception. You have to go through the 5-part test. But of course, and also we're in New South Wales. We're not in England. So you in New South Wales, you apply the New South Wales test. The test as was identified by a judge of the Supreme Court in New South Wales. And applying that test to the facts before him, he found that there had been a practical benefit, and so the promise to accept reduced rent was enforceable against the landlord. Terrific. So that finishes my discussion of the practical benefit exception. I'm going to move on to the second exception, which is a duty owed to a third party. This is more straightforward. It's simply that a promise to perform an existing legal duty to a third party is valid consideration. And this was described by Lord Scarman from that case of Powell. And I've given you just a quote from what we said on this, because it's because it is quite a simple rule. Their lordships do not doubt that a promise to perform a pre-existing contractual obligation to a third party can be valid consideration. And in terms of what gains the promise, there is something new. In short, the promisee obtains the benefit of a direct obligation. So you may wish to pause to take it down, but that's it. It's as I say, a more straightforward rule. And but to clarify it, I'm now going to give you an example to illustrate. So take this situation. So Andrea regularly contracts Ben to edit the videos that she creates. So Andrea creates videos and she gets Ben to edit them for a fee. Ben uses his own equipment. One day Ben's breaks down, and so he takes it to Christelle to fix it, and she promises to have it fixed by Saturday for a fee of $1,000. So that's a contract between Ben and Christelle. Christelle's under a contractual obligation to Ben to fix it by Saturday in return for a promise to pay $1,000. Christelle, she's frantically busy, so on Thursday she tells Ben that she's unlikely to make the deadline. Now, Andrea really needs Ben for an editing project over the weekend, so she contacts Christelle. She's not party to the original contract, but she contracts Christelle, and she promises to pay her an additional $400 if Christelle promises to finish the repairs by Saturday. Christelle agrees, and after working overtime, she completes the repairs on time. In this situation, the only thing that Christelle has in return for the promise of the additional $400, the promise from Andrea, all that Christelle has given is promising to do what she's already legally obliged to do. But her existing legal obligation is to Ben. And by virtue of this second agreement, she acquires a legal duty to Andrea. And that's new. So her existing legal obligation was to Ben, a third party. Here, her promises to Andrea. That creates a new obligation, a new contract. It's fresh, so it is new consideration. So in that situation, even though she was under an existing legal duty rule, there's something new, there's something fresh, there's something legally different, and there is something legally new. And so with Andrea getting the benefit of a direct obligation, that promise is enforceable, and so Christelle is entitled to that additional $400 because she did what was required of her. Terrific. So again, just to zoom out and remind us, this is existing legal duty rule. We've looked at the general rule, we've looked at the situation of part payment of debts, and we've looked at the practical benefit exception, promises to third parties. Now we get to the final exception, which is that of genuine compromises. And this is where we look at the case of Wigan and Edwards. Wigan was a builder who built houses and then sold them. So he constructed houses for sale. And this was a case about one of such houses. Before the house was completed, he entered into a contract to sell it to Mr. and Mrs. Edwards, to the Edwards. So of course the contract provided that the house was to be completed before they were to pay the balance and become the owners. So it's kind of like an off-the-plan sale, if you like. So before it was completed, he entered into a contract that when the house was complete, they would pay the balance of the purchase price and the land would be transferred to them. Shortly after they signed the contract, the Edwards inspected the premises and they pointed out a number of defects. And they said that these defects would need to be rectified. They would need to be fixed. So these faults would need to be fixed before they would complete the contract. They said, we're not going to go ahead with it until you've fixed these faults. So they weren't going to complete the agreement until they'd been fixed. So to reassure them, Wigan signed a document in which he agreed to fix all the defects and the major faults in the first 5 years. And the Edwards went ahead and completed the purchase. So I'm going to illustrate this. So the original agreement, the sale contract was Wigan promising to transfer the house to the Edwards in return for them promising to pay the purchase price. Subsequently, they discovered there were some faults. They said, we need you to rectify those, otherwise we're not going to complete. We're not going to go ahead with the bargain. And so there was a second agreement. It was a signed document from Wigan in which he promised to make repairs for the first 5 years. And in return, Edwards agreed to go ahead with the contract that they were otherwise threatening to back out of. Now, after it's important to be clear that the original sale agreement itself contained no warranties. So there were no promises in this original agreement as to the quality of the house. It was merely to deliver up a constructed house. So there was no promises about defects in that original agreement. The only promises about defects were made here. That's where Wigan said he would repair any of major defects within the first 5-year period. And that was on a signed document. And it was on that basis that Edwards agreed to continue. And so there were defects, there were major defects discovered, including a fault with the slab. And so the Edwards sued Wiggins. They were successful initially, it was appealed. And Wigan argued that, sure, he had made this promise that he would enforce, but it was in his subsequent agreement, not in the original, and he had received nothing in return. That is, all that he'd been given in return was their agreement to complete the contract, but of course that's an existing legal duty. They were already obliged to complete the contract by virtue of there being a contract, right? So he said, sure, I made that promise, but I didn't get any consideration for it, so it's not a promise that is binding on me. The existing legal duty rule applies here. So again, it's always very useful to just be clear exactly about, set out the nature of the bargain, the agreement, the this for that, and clarify what is the existing legal duty that's purported to be in play here. What was given for what? And you can see, well, this agreement to complete is the promise to perform an existing legal duty or the performance of. Now, it's clear that this situation did fall within the existing legal duty rule. That's clear. So it was, but it was found that there was another exception, the third exception that applied. And that exception is, in the words of Justice Mason, as there was a promise to do precisely what the promisor is already bound to do. Is that it's a sufficient consideration when it is given by way of a bona fide compromise of a disputed claim. So where there is a claim, where there is a dispute about about the enforceability of the requirements to continue under the original contract, where there's a dispute about whether the parties have to go ahead with that, about the rights, and they agree to continue with that, with that original contract. That can be consideration where it is given to settle that disputed claim. And they said that was the case here. So here, the Edwards disputed being required to complete the contract. They said they weren't. They were under the belief, and they were concerned about the nature of the house, and they were under the belief that they were genuinely under the belief that they did not need to complete. And they said, we're not going to go ahead with it unless you do this. And they were given, so they were then given that promise, the promise to rectify any faults that are discovered in the first 5 years, and they went ahead on that basis. Now, going ahead on that basis was doing what they were already required to do, but it was given so as to settle the disputed claim. And so they said the exception applies here. So it meant that the 5-year warranty was enforceable against Wigan. There are a few things to note about this exception. The first is that it's not necessary to prove that you wouldn't have been required to go ahead with the original contract. So it's not necessary to demonstrate that something went, there was a fault in the other party's work and you would have been able to withdraw from the contract. It's not necessary to show that you would have been able to withdraw. It's enough that there is a bona fide dispute. And the requirement that it's bona fide, which means that it's in good faith, that there's a dispute in good faith, that the purported claim that you're not required to go ahead is in good faith, that protects against misuse of the rule. So Justice Mason said the law, by insisting that the claim in dispute is one that was honestly or bona fide made, prevents this exception from being used by a party who would seek to gain an unfair advantage. So it has to be bona fide. You have to genuinely believe that there's a dispute as to whether you're required to go ahead with the contract. And it's also not necessary to show that you're planning to take that to court. Justice Mason said, a threat to bring an action or enter a defence, it's not an essential element of a bona fide compromise claim. It's enough that there's a claim. It's a claim that the contract party is not bound to perform the contract. That's what there needs to be. And that's what the Edwards thought here. They thought that they weren't required to perform the contract. And Justice Mason went on to say the judge found that the respondents honestly believed that having regard to the defective condition of the house, they were not bound to complete. Now, in fact, that wasn't the case. And perhaps if they'd received legal advice, that would have been made clear to them, but they hadn't. And so they were genuinely and honestly of the impression that they weren't required to, and they agreed to, in return, they agreed to go ahead with the contract in return for the promises they were given, and so that's consideration for those subsequent promises. Great, so that's that third exception. The final topic that I'm going to discuss today, I'm only going to discuss briefly, and it is only addressed briefly in really the final page of the readings, and it's about the function of consideration. And we're not going to get far with it today, but it's simply to make the point that it is legitimate to ask what exactly does consideration do and how well does it serve its functions. So remember, consideration is one of the four elements of contract formation. For a contract to be binding, there needs to be agreement, which often acceptance normally. So it needs to be agreement, consideration, an intention to create legal relations, and it needs to be sufficiently certain. Those are the four requirements that we look at in the first 3 weeks of the course, and you're going to be, they're going to be second nature to you. So agreement, consideration, intention to create legal relations, and certainty. And it's a genuine question to ask, well, what exactly does consideration add? Why is it useful to have this? Why aren't three, put another way, why is three not enough? I mean, there are, if you like, kind of four functions that it said that consideration performs. One of them is that it can be used to distinguish fair and unfair contracts, but we've seen how that's not something it does particularly well. Consideration need only be sufficient. It doesn't need to be commensurate. It doesn't need to be the case that a bargain is fair for there to be consideration. So it's not something that it's particularly directed to. It's not something that does particularly well. The second thing is that it said that consideration, the fact that there's parties each bringing something to it, is said to, it's been an indication that the parties are intending to be bound to the bargain. And it can be a useful indicator, but not always. But I mean, there is separately a requirement that the parties must intend to be legally bound. And to be clear, not all legal jurisdictions separately require consideration. In civil countries, it isn't a separate requirement. And you could argue that that's not necessary. It's enough if you're intending to be legally bound. Why is it then necessary that there needs to be something given in return? It does, in a practical sense, there's a third function it provides, which is to provide a kind of a formal requirement. It just sort of, again, makes clear. This can be useful, like even if there's nominal consideration, it does then sort of an expression of the fact that the parties are trying to create something that's binding. And another thing sort of related to the first is that it's, people make promises all the time, sometimes foolish promises, sometimes ill-considered promises. And, if they're not made for consideration, then they can be released from those obligations, and, the consideration obligation, the consideration requirement can perform a useful role there, it said. But again, why distinguish? A foolish promise might have been given in return for nominal consideration, and that would be binding on you. So how well is consideration performing that function? So this is a very broad and just general test. It's just intended to be clear that it's not, this is the way the law is developed. This has become a central requirement for there to be a binding contract. It is part of our law, but it is legitimate to ask what function it serves and whether it's performing that function well. Okay, terrific. So that brings us to the end of this second lecture and the final lecture for this week. We return next week for the new topics of certainty and intention to create legal relations. We'll see you then.